I'm Dru Stevenson, and this is one of my introductory lectures about administrative law and regulatory agencies. Here I'm going to be talking about the legal backdrop, the big picture legal framework to help my students get their bearings before we start studying cases and individual or specific legal concepts. So, and again, this is going to be useful not only for an administrative law class, but also for statutory interpretation and regulation classes or Leg-Reg classes that have a section of the semester that's about the administrative state. So let's dive in here and get our bearings. Okay, the first thing you need to understand is the statutes. So let's talk about the statutes. And for purposes of this area of law, we can really talk about two types of statutes. And the first type is going to be enabling statutes. Sometimes these are called the organic statute or the governing statute in a case or by your casebook authors. And examples would be, say, the Endangered Species Act, which is pictured here, the Clean Air Act, the National Labor Relations Act, the Federal Trade Commission Act, and so on. And there's hundreds and hundreds of these, right? And some create agencies and then they empower agencies. Some, if an agency already exists, a new act may give new powers and authority or tasks to that agency. And so basically these statutes are acts of Congress or on the state level, a state legislature that delegate authority to regulate, to enforce, to run different types of programs. And these things also restrain the agencies, right? So they empower them and they also set the boundaries of their authority. And so this is their statutory mandate that not only gives them the legal authority to act, but also sets the limits or the parameters of their authority. Now, we also have in this area of law some very important general or generic statutes that apply to every agency with a few exceptions. And the big one is the Administrative Procedure Act that was passed in the late 1940s, again pictured here. And another example would be the Freedom of Information Act, which we usually just call FOIA, or the National Environmental Policy Act, NEPA. And what these do is they create basically procedural requirements or protocols that all the agencies have to follow. So the Administrative Procedure Act, which we will have a whole unit on, spells out different methods or processes for promulgating rules or adjudicating cases and running hearings, and a little bit about judicial review and the standards of review that courts are going to use. The Freedom of Information Act is a transparency in government statute that allows private parties to petition an agency for information that agency has. Agencies collect a lot of information. And so again, this isn't anything substantive about agencies have to implement certain policies. This is just about making documents available to the public upon request. And then the National Environmental Policy Act basically requires the agency to do some procedural steps of studying the environmental impact of their actions before they take them. Now, we have other legal texts that are going to come up in this course and that affect the agencies and that are part of this, again, body of law that agency officials and regulators have to follow. So we have executive orders and then probably secondarily presidential memoranda and so forth. There's not a big legal difference between these, but a president as the head of the executive branch can direct agencies to do certain things. And often this is put in very official written form and published and studied so that there's a document of it. We also have some judicially created law or judicial doctrines, like certain very specific due process requirements, something we call hard look review that we will look at later in the course, presumption against preemption, and so forth. And so what has happened is, as the judiciary deals with agencies as parties to a case, in a lot of cases, either because someone is challenging something that an agency has done or the agency is bringing an enforcement action, courts have created special rules for how they're going to handle agencies or that they expect agencies to follow before they ever get into court. And that in turn becomes part of the body of law. Now, the Supreme Court has insisted that we don't really have a federal common law of administrative law. And there's a sense in which that's true, but we also do have a line of precedents that the agencies are very aware of. Okay, also keep in mind that we have law made by agencies. And as a student, it's pretty important to keep this straight in your mind as you're working through the cases. When are we talking about a law that's directed or addressed to the agency that the agency has to follow? And when is the agency essentially creating law that the regulated industry or the regulated parties have to follow? So when regulations are promulgated by the agency, they're initially published in the Federal Register, and then they'll end up codified in the Code of Federal Regulations. So the CFR is all law generated by regulatory agencies. And in your library, if you've ever wandered around your law library, the the set of CFR books, which is much longer than the United States Code, is usually in the neighborhood, right around the same bookshelf as the USC, because it has force of law. But these are legal rules not enacted by Congress, but promulgated by regulatory agencies. Agencies also put out guidance letters, things they call memoranda, and so forth. And we're going to do a unit of this course about whether these have the force of law or not. That's actually a critical question. Also, agencies can do common law style, like case by case announcing of rules and sort of creating within precedent within that agency's purview. So if the National Labor Relations Board wants to announce a new policy in a case and an enforcement action that they're bringing, they can do that subject to certain conditions and can announce policy going forward. So this is now how we are going to apply our statute or apply this rule to different cases. And this will should be reminiscent to students of the common law judicial precedence system. Also, we have some constitutional issues in this course, and frankly, this is the part of administrative law that you can actually see on the bar exam, like the multi-state bar exam, as con law questions. So we have a whole unit of, when we do administrative law or a section of a Leg-Reg course, a regulation course about the administrative state, we have a whole section about the non-delegation doctrine, which is sort of a subset of separation of powers. And so keep in mind, agencies are going to engage in lawmaking in the form of regulations, executive actions in the terms of enforcement, or issuing permits and licenses or dispersing funds, and adjudication, usually through administrative law judges. And there's also some constitutional cases that we have in this body of law about procedural due process. What kind of procedural fairness does an agency have to give to a party when they're deciding a case? Okay, that concludes our quick introductory lecture about the legal backdrop for administrative law.